Hello, and welcome to our webinar, Don't Be Surprised by the No Surprises Act. My name is Chelsea Grover, and I'm the Marketing Manager for DAS Health. Before we get started on today's webinar, I want to take a moment to explain the process for today's presentation. First, I'd like to mention that this webinar will be recorded and that we'll send out a copy of the slides along with the recording within the next week. Next, I wanted to remind you of some super exciting news. Itentiv is now part of DAS Health. Now it looks like we have a nice mix of current DAS Health clients as well as clients who came through us through Itentiv. So I'm going to do a quick rundown of who we are at DAS, just as a quick refresher for those of you who don't know. DAS Health is a leading provider of health IT and management solutions and a trusted consultant to many physicians groups, hospitals, and healthcare systems across North America. By combining our skills and expertise, we'll be able to provide even more support, value, and solutions to your practice. And we're looking forward to continuing to serve you under our new name. This month, you'll see Itentiv transition our emails and social media channels to the DAS name. So please, 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 please start following us at DAS Health and keep your eyes out for our new emails. And again, I want to reassure you that we're still here for you. We're still going to be here specializing in NextGen and keeping our focus on you. We're still passionate about providing solutions for healthcare provider partners, which in turn help them to improve patient care, enhance the patient experience, and maintain a financially healthy practice. And we're still going to keep doing everything NextGen, including add-on productivity solutions like ChartGuard, Refund Manager, Unapplied and Deposit Manager, and Multiple Encounter Billing Manager. And now we also support Aprima, EMD, MedSoft Clinical, YTech, and Athena Clinical Works, just to name a few, along with patient care solutions, information technology solutions and hosting, and government incentive reportings. Next, I want to mention some upcoming webinars. For those of you on NextGen, tomorrow we'll be presenting a brief live demo of our NextGen add-on solution, ChartGuard, which automatically creates PDF backups of your patient charts so that you can always have access to their records, even during a system outage. Please use the chat box to let us know if you'd like to attend that demo and we'll get you set up. And next week, we're going to be presenting another government incentive webinar on everything you need to know for MIPS 2022 and beyond. An invitation for that's going to go out later this afternoon, so keep your eyes peeled for it. Okay, so back to today's webinar on the No Surprises Act. At the end of the presentation, we'll open the floor up to questions from you. Now, I do want to give you fair warning that we're going to be really crunched on time for today's webinar due to the complexity of all the information that we'll be presenting. We'll do our best to get through as many questions as we can, but we may have to cut the Q&A segment short. We would, however, still encourage you to get your questions answered from somebody knowledgeable on the topic, for example, your legal or compliance departments. And finally, for audio clarity purposes, everyone's phone will remain muted throughout the entire webinar. If you experience audio issues, please use the chat box to let us know so we can resolve them. Okay, so without further delay, I'd like to introduce our presenters for today. Helen Lively is Integrated Healthcare Solutions Analyst, and Lindsay Lanning is the Government Incentives Manager at DAS Health, which means that both of these ladies are experts on the topic and super eager to share their knowledge with you today. And I really do mean eager. I mean, like these ladies are so excited. So with that, Lindsay, I'm going to go ahead and let you get started.
Great. Well, thank you, Chelsea, and thank you everyone for joining our webinar today on the No Surprises Act. So as of January 1st, 2022, that again is January 1st of this current year, the No Surprises Act requirements went into effect. So this is not upcoming, this ship has landed, ladies and gentlemen, and we are in the thick of it as we are already in July. So, as a result, our plan for today is to introduce this new piece of legislation and explore the implications it will actually have on your practice. We're going to examine all three rules and provide information to help you understand the requirements and to better address compliance in your own organizations. Now, if the cheesy title, which I am ridiculously proud of, wasn't a dead giveaway, I would say the introduction slide with my title and picture should have been, but I am not a lawyer, and I absolutely do not pretend to be a lawyer. I wanted to start out with this clarification because I am here today as an industry expert offering you my understanding of this massive piece of legislation and how it will impact your practice based off hours of endless research. So again, this is not, hard and fast legal advice. The nuances and the details of this law are intense and they're super specific. So while, specific practice questions might come up, they may require some follow-up or some, deeper digging on your behalf, or to reach out to, your compliance department or legal department like Chelsea mentioned. So our goal today is to make sure you're aware of the regulations and walk away, having a better understanding of what they require and what you need to be concerned about addressing in your own organization today. Now, in order to understand this legislation, you need to know why it matters. And in order to know why it matters, we're going to have to start with the basics. So first and foremost, what even is surprise billing? So what's called a balance bill may come as a surprise for many people. A surprise bill is actually an unexpected bill from a healthcare provider or facility. Pretty straightforward. This can happen when a person with health insurance, unknowingly gets some sort of medical treatment or care from a provider, a facility, or some sort of air ambulance service outside of their health plan's network. And surprise bills are going to be expensive for the patient, their insurance, and even the overall healthcare system. And that's what we like to call a lose, lose, lose. Now, this situation can happen when you can't control who's involved in your care, like when you have an emergency or maybe when you schedule a visit at an in-network facility, but you're unexpectedly treated by an out-of-network provider. So if you think about it, in an emergency, an individual usually gets care at the nearest emergency department, right? Even if they go to an in-network hospital for that emergency care, they might get care from an out-of-network provider who are at that hospital at the time. And even for non-emergency care, an individual might actually choose an in-network facility or an in-network provider, but not know that a provider who's involved in their care, in some way, shape, or form, for example, an anesthesiologist or maybe a radiologist, is actually an out-of-network provider. So in some of these instances, a person can actually receive a surprise bill from an out-of-network provider that's higher than the amount they would have otherwise paid or had planned for with their in-network care. So the No Surprises Act protects these individuals from large and unexpected surprise bills. So official, the No Surprises Act establishes federal safeguards against surprise medical bills, and these have taken effect on January 1st, 2022. It was actually initially released by CMS on July 1st of 2021 to implement these key provisions of the No Surprises Act. So that's when the rule came out and enforcement, started taking place this year. The goal of this act is really two things: to protect patients from those unknown costs of care and also ensure patients have access to the necessary information to understand the true cost of their healthcare services. And bottom line, to really sum it up, the Federal No Surprises Act, and we're going to refer to that as the NSA sometimes today, prohibits out-of-network healthcare providers and facilities from balance billing commercially insured patients in these certain circumstances. So that's kind of the true takeaway here to keep in mind when we're going through these slides today. Now, who all is protected by this legislation? So this No Surprises Act requirements are going to apply to any items and services provided to most individuals who are enrolled in private or commercial healthcare coverage. So that's going to be the employment-based group health plans, both self-insured and fully insured. It's going to be any individual or group health coverage on or outside the federal or state-based exchanges. It will include federal employee health benefit plans, and any non-federal government plans sponsored by state and local government employers, and it will even include student health insurance coverage. Some requirements, which we'll talk about today, also do apply to providers and facilities with respect to uninsured or self-pay individuals. Now, one thing to point out is that these requirements under the NSA don't apply to beneficiaries enrolled in Medicare, Medicaid, Indian Health Services, Veterans Affairs Healthcare, or TRICARE. Now, the burning question, I am surprised hasn't already been put in the chat yet, is who must actually comply with the No Surprises Act? And the answer, the No Surprises Act requirements apply to all healthcare providers and healthcare facilities. The statute does not exempt any categories of providers or facilities from this requirement. That is taken directly from the law. I almost want to take a moment of silence to really let that sink in. All providers with no exemption. So now that I am sure I have your attention, let's go ahead and look at what the NSA does exactly. So this is taken directly from CMS and what they state this does. So first and foremost, it's going to prohibit providers and facilities from directly billing individuals for the difference between the amount they charge and the amount that the individual's plan or coverage will pay, plus the individual's cost sharing amounts. It requires providers and facilities to provide good faith estimates of charges for care that's to be furnished to any uninsured or self-pay individuals upon scheduling care. It creates a patient-provider dispute resolution process for uninsured or self-pay individuals to contest any charges that are in excess of that estimate. It requires certain providers and facilities to publicly disclose restrictions on balance billing. And it limits billed amounts in situations where a provider's network status changes mid-treatment or individuals act on, inaccurate provider directory information. So again, keeping this in mind with no providers being exempt from this, this is really what this act is aiming to do. So when do these rules on surprise medical billing apply? Well, out-of-network emergency services provided at a hospital emergency department or an independent, freestanding emergency department or by air ambulance, not ground ambulance, and then non-emergency care rendered by an out-of-network provider at an in-network hospital or ASC, ambulatory surgery center, unless the patient has consented to be treated by that out-of-network provider and agrees to be balance billed. So what this means is a lot of this rule, may not apply to you if you don't practice in a hospital or an emergency department or ASC setting. At least large parts of this balance billing portion of it. We are still going to break this down to a point and show what's required from an ambulatory provider perspective. As I know, a lot of our ambulatory providers or providers that are typically practicing at a private office do still provide care at various hospitals. So again, that true surprise billing portion is going to apply to providers in a hospital or ASC, but there are certain parts and pieces of this legislation that will apply to you all at an outpatient, ambulatory setting as well. Now, the timeline of this legislation started back in July of 2021. So a year ago exactly, they released part one, or the first rule. And then we had the second rule come shortly after in September, and then the third and final rule in October, all with an effective date of January 1st of this year. So again, we're going to look at each of these three rules and what it requires and who it impacts. This is just to show you a general overview of the various sections of the NSA and when they were actually introduced and released. I know a lot of people that I've been talking to recently have said, "Did I miss something? I don't know if I knew when these came out." It was a quicker implementation timeline than what we've seen with large, legislation like this. So this all came about and started 1 year ago today exactly, with that first rule being released. So like I said, there are other portions in each part of these rules that will impact you, which is why we're doing a whole webinar on it. But to identify, exactly what went into effect 6 months ago is going to be that no balance billing allowed for out-of-network emergency services, no balance billing for non-emergency services by any of those non-participating providers at certain, in-network or participating healthcare facilities, the requirement to disclose patient protections against balance billing, that again, no, preventing that balance billing for any sort of air ambulance services, ensuring the continuity of care when a provider's network status changes, improving provider directories, and of course, provide good faith estimates in advance of scheduled services or upon request for any uninsured or self-pay individuals. Now, I bolded this last bullet because I think this requirement in particular is having the largest impact on ambulatory providers right now, specifically trying to find ways to use your EHRs to get this estimate to patients to be in compliance with this rule. So we're going to spend some extra time on this today as well. Now, I know our initial reaction to any sort of regulation mandating our providers to do something is typically met with, some pushback, maybe some negative thoughts or feelings. I get it. I don't live in a fairy tale land, but there are a lot of pros to this. One being, even though we work with providers, or maybe you are a provider, we are all still patients at some point in our lives. So these do benefit us. But think about your patients who may struggle with these issues and some issues that you've experienced in your own practice. It's now going to force health plans to cover out-of-network emergency services on an in-network basis without prior authorization. It's also going to create a process for determining rates paid to out-of-network providers. It's also going to mandate that health plans either deny or make an initial payment after 30 days once a provider submits clean claims. So I know that's going to be a big win to have that, either denial or that initial payment within 30 days, no matter what. And then of course it creates this process for payment disputes between the provider and the health plan. So with those positives in mind, let's look at the 3 rules and kind of what each one does. So rule 1 is part of, one of the requirements related to surprise billing. It's that part 1. So this rule is going to protect individuals from surprise medical bills for emergency services that we've been talking about. This is the one that goes through, the air ambulance services by out-of-network providers and any sort of non-emergency services provided by out-of-network providers at an in-network facility. So if a plan or coverage, healthcare coverage provides or covers any sort of benefits for emergency services, this is going to require emergency services to be covered. And it's not going to require any prior authorization. It's going to be covered regardless of whether the provider is an in-network provider or an in-network emergency facility. And it's going to be regardless of any other term or condition of the plan or coverage other than the exclusion or coordination of benefits or permitted affiliation. It also limits cost sharing for out-of-network services to no higher than the in-network levels and requires the cost sharing to count toward any in-network deductibles and also prohibits balance billing. So generally, this rule 1 is going to really impact providers and groups who perform services in a hospital or emergency department or some sort of facility setting. Now, rule 2, on September 30th, 2021, the second requirements related to surprise billing rule was issued. So kind of part 2 here. And it provided additional support against surprise medical bills that included things like creating an independent dispute resolution process to actually determine that out-of-network payment between providers and facilities in the health plans. This second rule is the one that required good faith estimates for any medical services or items that are provided to uninsured or self-pay patients. It also set up the patient-provider resolution process for disputes pertaining to any uninsured or self-pay patient, between the provider and the patient. And it also supplied a way to appeal certain decisions made by health plans. So this rule actually, is the one that broadly applies to basically all providers in all settings. So that's why we went ahead and started that one today. And last but not least is Rule 3. This was issued in November 17th actually of last year, and this is called the Prescription Drug and Healthcare Spending Rule. This is going to enforce requirements for group health plans to submit certain information about prescription drug and healthcare spending. So it's going to include information on, what drugs were most frequently dispensed, the costliest drugs, some enrollment and premium information, and it's going to include average monthly premiums paid by employees versus employers. So again, our biggest provider impact rule is going to be really Rule 2 today. It's going to apply to the most, the most amount of provider types and specialties and facilities and settings. And then would be Rule 1. Rule 3 is really focused on, the healthcare spending and looking at health plans as well. Now, you can also look at this law, and instead of looking at each rule, you could actually divide it up into 3 areas. So you have the surprise billing, you have the provider obligations, and then you have the payer obligations. Obviously our focus is going to be on the provider obligations. So that's going to include, the consumer notices that need to be on the websites, making sure that you determine the insured status of patients, good faith estimates, the notice and consents that are required, and the patient provider dispute resolution. We're also going to look at some of the surprise billing sections as well. Specifically, we've really talked about the balance billing requirements for certain services, but we'll also look at the federal IDR process or independent dispute resolution process and what that looks like from the provider side if you'd be included in that. Now, again, sadly, I didn't make this image. It was actually taken directly from the AMA webinar that was hosted by Manat Health, but it shows you really the main points of impact for your specific practice, which is why I liked it so much. Now, this slide in particular, is really going to guide our conversation today. So instead of going rule by rule or overwhelming you with all the details of what health plans, are responsible, we're just going to cover exactly what providers need to know by looking at notices and consents, the good faith estimates, the patient provider dispute process, and the independent dispute resolution process. So let's start with notices and consents. First is a blanket disclosure requirement that every provider, hospital, and ASC is going to be required to make publicly available, including on its website and to each patient who's enrolled in any sort of commercial healthcare coverage. So basically, it's a disclosure regarding the patient protections against balance billing. So again, as of January 1st, 2022, this notice should be posted on your websites. It must contain information on the requirements established under this law and information on any kind of state level protections if applicable. It also needs to include contact information for state and federal agencies to report any potential violations. So the U.S. Department of Health and Human Services, or HHS, they actually created a model notice. It provides all that information, and we recommend that you can and should use this. Again, that notice needs to be provided individually to commercially insured patients no later than the time a bill is sent to the patient or a claim for payment is submitted to the health plan. And I went ahead and actually linked the model notice here in the slide. So when you get these slides, you'll have access to this. Again, while the NSA has various requirements for different providers, this is something we recommend updating on your website no matter what. It's a quick fix and it's something that we need to do to be in compliance. Next are consents. So these are the consents you can obtain from patients to balance bill them. Now, some reminders just to keep in mind. The surprise billing protections are somewhat narrow, right? They only apply to either emergency services at a hospital, ED, a freestanding emergency department, or an out-of-network services at a hospital or ASC. And all of that only applies to insured patients. So again, just reminding you of the scope of this legislation in relation to the balance billing portion of it. So an out-of-network provider can actually balance bill a patient for items or services if they satisfy this notice and consent process established under the law. So again, this is gaining the patient's consent to balance bill them. If you're in a hospital or an ASC setting and you provided some sort of out-of-network care to an insured patient, then this written notice and consent must be received within 72 hours of the item or service being delivered. Now, the notice can be in paper or electronic form. The patient is the one who will select which one. And the notice must contain some of the following information. It needs to have, notification that the provider is out of network, clear as day, a good faith estimate of the charges, a list of in-network providers at the facility, if the facility is in network, to which the patient can be referred, and information on any prior authorization or care management requirements, and a clear statement that consent is optional and the patient can instead opt for an in-network provider. Now, when it comes to the actual form, HHS again developed a standard notice and consent document. If one of your patients signs these forms, they're agreeing to give up their federal consumer protection against unexpected medical bills. So some of the situations where you would be allowed to ask a patient to sign one would be if they schedule a non-emergency service at an in-network hospital or some sort of ASC, but your provider is out of network, or if they need care after an emergency, which they refer to as post-stabilization care, and their provider or facility is out of network. So again, these notice and consent forms apply, only to people with private health insurance who are getting out-of-network care for certain non-emergency services. And these consents, again, need to inform the patient that they're getting care that's out of their plan's network, and that they can contact their health plan to find an in-network provider if they want. Understand that this consent needs to explain that signing this form means that they're agreeing to get care from that out-of-network, which may cost more. And it needs to explain the estimated out-of-network cost that they are agreeing to give up or waiving their right by signing that consent form. Now, there are exceptions to this notice and consent process, I should say. Some of these include, patients receiving any sort of the following non-emergency ancillary services. They cannot be billed beyond their in-network cost-sharing amount. So in other words, the notice of consent option can't be used for these services. And these are going to include items and services related to anything like emergency medicine, anesthesiology, pathology, radiology, and even diagnostic services like radiology and lab services. In addition, any out-of-network provider cannot use the notice and consent process if there's no in-network provider available to furnish that same item or service at the facility. So the idea here is that these aren't services that are really shoppable. You can't use this notice and consent process unless the service is shoppable. So in contrast, if it's a surgery, maybe, it's a procedure where you can pick the provider in advance, it's shoppable, and they just want to maybe have it done at an in-network hospital. But that's when, a great example, the patient can consent to pay the out-of-network rate to get it done where they want. Okay, so here was a great graphic from the AMA presentation. It breaks down when you can obtain consent to balance bill or when you cannot, and really summarizes everything I just went over. It goes over that not being able to obtain consent for services where patient choice is unlikely. It shows you where that standard HHS notice needs to be provided, and that that needs to be provided 72 hours in advance. And then again, same thing. It goes over when a provider is able versus is not able to gain that consent from that patient. Now, the first thing that comes to mind, after learning this information is, well, how does the provider even notify the health plan that it obtained consent to balance bill? Well, when you're submitting a claim to a health plan, that out-of-network provider has to indicate that the service was rendered during a visit to an in-network facility and provide a copy of the signed consent to bill that out-of-network rate. And if the provider bills the patient directly, same thing. The provider is going to have to satisfy this requirement by including a copy of that signed consent with the bill. And health plans should be fully aware of this. They should be expecting this. And then, of course, I wanted to show you an example of this consent, the consent that I referenced, taken right from HHS. So this is page 1. You can see in plain language, it's very easy to understand, explaining to the patient, really what a surprise bill is and what, by signing this form, they'd be giving up. It's always going to include the patient name, the out-of-network provider name, an estimate of what you could pay, and it goes over those indications that we talked about being able to call your health plan and understanding your options. Next is going to list the items or services that are expected here. And then again, that last page would be, that true consent portion where they go over in a detailed description bulleted of, what you are consenting to and what you are giving up. And then it includes the patient signature, obviously. And last but not least, something extremely important to note is the documentation retention for these consents. So what has been dictated through this law is that if the in-network facility assists in obtaining this consent, they're the ones responsible for retaining it for 7 years. If the out-of-network provider directly obtains that consent, that provider must retain the consent for 7 years or arrange for the facility to do so. But long story short, we are looking at a 7-year documentation retention. This is longer than our normal. I think typically the OIG and HHS defaulted to 6 years. So I did want to call this out that, this is now something that we need to keep and have on file to back up any sort of consents received for balance billing. Now, a different type of disclosure that I mentioned, or alluded to in the previous section or slides here was this good faith estimate. So this requirement's not really limited to any provider type. So it's likely going to impact you in your practice. It's anyone who sees any uninsured patients or patients that choose not to use their insurance and self-pay. So that could be essentially any provider or any patient. So the new requirement is for healthcare providers to share what are called good faith estimates. I'll probably refer to them as GFEs of the total expected charges for scheduled items or services. And that's going to include any expected ancillary services with a health plan if the patient's insured, or if the individual is not insured with that specific individual. Now, the notice will also need to include the expected billing and diagnostic codes for all items and services to be provided. And this requirement is going to apply whenever items or services are scheduled at least 3 days in advance or when requested by a patient. So what all of you on this call need to be doing as of January 1st of this year is providing these estimates or these good faith estimates of the expected charges in advance of scheduled services or upon request to any uninsured or self-pay patients. So this means that your practice has to inquire within a specific time frame If an individual who schedules an item or service with your practice is enrolled in a group health plan, a group or individual health insurance coverage offered by a healthcare insurance, maybe a federal healthcare program, et cetera. If they have some sort of insurance, you need to ask them. And then if they are covered, you have to then ask if that individual plans to use that health insurance or plans to have their claims submitted to their health plan, or if they plan on paying for it themselves. Now, if they're not insured or they're not planning to use their insurance, then the practice has to provide notification of that good faith estimate of the expected charges, expected services, and the diagnostic codes of the scheduled services. And this GFE must be issued upon request or upon when the service is scheduled. If a patient requests that good faith estimate and later schedules care, a new good faith estimate must be issued prior to furnishing that care. And this estimate, again, has to include the cost for the entire period of care, or that means, the day or multiple days in which the primary service is being performed, and any other additional services that will likely be furnished in conjunction with the primary service. So let me give an example here. Let's say you provide a good faith estimate for a surgery. It's going to include the cost of the surgery, but it's also going to include the pre and post labs and tests, as well as anesthesia, etc. It will not include items related to the surgery that may be scheduled separately. So, for example, think of like PT after. So you can see a graphic created by MGMA that tells you if a good faith estimate needs to be created or not, reiterating what I just explained. I like these kind of flow charts here where they ask you the questions and they can point you in the right direction. Now, practices have to provide these estimates to patients when a service has been scheduled. The GFE is to be provided no later than 1 business day after the date of scheduling. If the service is scheduled at least 3 business days before the service, and within 3 business days of scheduling if the service is scheduled at least 10 business days in advance. Once the service is scheduled, a new good faith estimate must be provided. So again, not only that, but providers are expected to explain the good faith estimate too, if patients have any questions over the phone or in person, and then follow up again with that, either in writing on paper or electronic, whatever the patient prefers, that estimate. Again, another MGMA graphic, but it is a good one. This is going to show you the timeline expected by CMS for providing these GFEs. So you can see it starts with the patient scheduling a service. Next, the convening provider. It's just a very technical term, but it really means the rendering provider or the one providing care needs to reach out to any co-providers to get an estimate for services they may need to provide. Again, think if this was a surgery, the surgeon would be the convening provider, but the anesthesiologist would be the co-provider. And next, you need to provide the full good faith estimate to the patient. So this means within 3 business days of that patient scheduling those services, they receive a good faith estimate, including all this information from your office. Now, there is a big win for us. There was a delay in that co-provider good faith estimate requirement. So for the 2022 calendar year, HHS stated they're not going to enforce the requirement that the convening provider GFE incorporate estimates from co-providers. So patients would be free, to request those estimates directly from those co-providers, and those providers would have to be required, to give that information. But for right now, for 2022, you're not responsible for any other provider's estimates included in yours. Now, this is still set to take effect in 2023. But many healthcare organizations have gotten together and written letters, like the snapshots you see, above or on the screen here, kind of pleading here to not implement this portion of the GFE requirement. Specifically, the letter to CMS with a lot of healthcare organizations on it stated that due to the lack of currently available automated solutions, this process would require a significant amount of manual effort by providers. Which would basically result in undoubtedly the provider not being able to meet the deadlines or that time frame. And they again were urging CMS to continue this enforcement discretion later on until they can figure out a comprehensive technical solution for this. So we'll see what happens, but as of now in 2023, this is still a requirement that will go into effect. Now, CMS has laid out a very detailed requirement for these good faith estimates. So I'm just going to read down the list of what they require quickly. Again, you'll have this reference when we send out the slide deck, but obviously first and foremost is the patient name and date of birth. You need a description of the primary item or service. Then you have to have that itemized list of services grouped by provider, the applicable diagnosis codes or expected service codes. Then you need the name, the NPI, and the tax ID of each provider. Again, the list of items or services the convening provider anticipates will require a separate scheduling or a separate GFE. You need to include a disclaimer that this is only an estimate. Should include information about the patient's right to enter into the patient-provider dispute resolution process, which we'll cover next. And then, of course, a statement indicating that the GFE is not a contract and it doesn't require that uninsured patient to receive services from this provider. So you can see here's a sample of a good faith estimate form from HHS. So you can see all the elements we just touched on are included here. Again, we have the patient information first and foremost. Then again, we're including the date of the good faith estimate with the providers and the estimated total cost. Then we have those details of the services provided and the total expected charges. Now I'm going to try and anticipate some questions I'm sure we probably already have gotten in the chat here. So the first one is, do physicians have to provide every self-pay patient a good faith estimate, or is it only when the patient requests one? So long answer short here, yes, it's to every uninsured or self-pay patient, whether it's requested or not when the service is scheduled. So under these rules, the provider is supposed to inquire whether that patient has insurance and if they intend to use that insurance. So if they say they do, then that physician doesn't have to comply with the good faith estimate requirement. If they say they have insurance but they don't intend to submit it or use it, then you're supposed to provide a good faith estimate. What happens if the good faith estimate items change before the service is furnished? So this is a big one that we get a lot. The convening provider must update the good faith estimate at least 1 business day before the service if it learns of or anticipates any changes to the scope prior to the GFE. So, and if any of the providers represented on that estimate change within 1 business day prior to the scheduled service, the replacement providers must accept the estimate as their own. And then how do we deliver the GFE to the patient? So this estimate must be provided either in writing or electronically, again, as requested by the patient. You can see a theme there. However, an electronic estimate must be provided in a way that the patient can both save and print it. And then, lastly, what happens if the charges end up being more than what was on the estimate? And this question requires a little more of a detailed response. For any patients that receive a bill over $400 more than the estimate that was provided prior to the service, they can dispute that bill using the patient-provider dispute resolution process. So this new process allows a patient to request that an independent third party, called a dispute resolution entity, review their case and determine an appropriate payment. So again, this is the patient-provider dispute resolution process. So the dispute resolution entity will review that good faith estimate, they'll review the bill and the information submitted by the provider or facility to determine if the patient should pay the amount on their good faith estimate, the actual billed charge, or an amount in between the two. So patients are eligible to use this process if they're uninsured or self-pay. Self-pay meaning they have insurance, but they didn't use it to pay for this specific service. If they scheduled and received medical care on or after January 1st of this year, if they have a good faith estimate from their provider, they have a bill date from within the last 120 calendar days, that's about 4 months, and the difference between the good faith estimate and the bill from any single provider is at least $400. Now, I do want to note the good faith estimate may have expected costs from more than one provider. Patients are only eligible for the patient-provider dispute resolution process if their bill from an individual provider is at least $400 more than the total expected cost on that estimate. So while this isn't as important this year, since the requirement to include other providers on your GFE has been delayed, you may not see this happening, but again, just in case, if a patient gets a good faith estimate for $1,000, and they have 2 providers on there, and each provider estimated $500 each. If the bill comes back to be $1,500 and one provider billed $800 and the other provider billed $700, they're not eligible for this process, because while the estimate in total was over $400 more, each provider was still within that $400 range. One provider was only $300 over and the other provider was only $200 over. So I hope that makes sense. So how will patients initiate this patient-provider dispute process? So a patient's going to initiate this by submitting an initiation notice to HHS, and this can be done online through a portal. Patients are going to need to provide or upload a copy of their good faith estimate and a copy of their bill to begin the process. And a $25 non-refundable admin fee is required to start this process. Now, if the dispute resolution entity decides in favor of the patient, this amount's just going to be deducted from the amount owed by your provider. So there is a financial deterrent here to not just submit these all the time, at least. They will have to pay that $25 to get this started. Now, after the initiation notice is received from the patient, HHS is actually going to refer that notice to the state and see if the state adopted its own patient-provider dispute resolution process. The dispute resolution entity will then actually notify the provider or facility if it determines the dispute is eligible for resolution, aka if the difference between the estimate amount and the billed amount exceeds $400, basically is what they're looking at it. And this is how you'll learn of that. Once you've been notified that the dispute resolution process has been initiated, the provider or facility, aka you all, have 10 business days to provide a copy of the disputed estimate and the bill and any documentation showing that the difference was based on a medically necessary item or service that couldn't have been reasonably anticipated when that estimate was provided. So you have a chance to kind of plead your case and provide that documentation. It just has to happen within 10 business days. During that time, you have to suspend all collections and accrual of late fees on any unpaid amounts while this resolution process is pending. And you must not take or threaten any punitive action for the patient's use of this dispute resolution process. And then an important thing to note here is that at any point after the dispute resolution process starts and before the determination is actually made, you can settle the payment amount on your own. Now that can be through financial assistance, maybe offering to let the patient pay an amount lower than the billed amount, or if for some reason the patient agrees to pay the billed charges in full. If you do reach an agreement on that payment amount, you are required to at least reduce your bill by at least half of that $25 admin fee. And you are the ones who are responsible for notifying the dispute resolution entity that a settlement was reached within 3 business days. So lots of timelines here and kind of deadlines to keep track of. Now, the provider-patient resolution process is not to be confused with the independent dispute resolution process. So the provider-patient process is for those that are uninsured or self-pay who got a good faith estimate over $400. The independent dispute resolution process, or the IDR, which I'll probably call it, is for those who receive out-of-network care and what the patient cost sharing should be since they could not balance bill due to this new regulation. So the IDR process, or the independent resolution process, is between the practice and the health plan, where the provider-patient process is between the provider and the patient. So the NSA is going to establish this IDR process for any sort of, out-of-network care covered under these surprise billing protections. So providers and health plans may use an independent arbiter to determine final payment for certain out-of-network care. So in general, health plans have 30 days to make an initial payment after receiving a clean claim. If the provider is unhappy, so if you all are unhappy with that initial payment amount or a denial, you have 30 days to initiate what they are calling an open negotiation period, which itself is 30 days long. Then this IDR process may be triggered during the 4 business days after the end of the negotiation period. So again, this is for physicians or providers who receive payment for out-of-network care. You should be aware of these deadlines to initiate that negotiation and that IDR process if you would like to balance bill. So here's a helpful diagram to remind you, who can balance bill under federal law and when the IDR process would apply. So again, if is the care provided emergency services? If it's a yes, then balance billing is not allowed. That's where you would have this independent dispute resolution process. If it's a no, are these services provided at an in-network facility by an out-of-network provider? If it's a no, then balance billing's allowed. You're taken care of, you can balance bill them. If that's a yes, then you need to ask yourself, are the services being provided ancillary services? Now, if that's a yes, remember we talked about this, you can't use that notice of consent policy for those types of services. So balance billing's not allowed. So that's where you would default to this IDR, federal IDR process to try and get paid something, right? If it's a no, the next question is, are there any other in-network providers available to furnish that care? Again, if there aren't any, you would not be allowed to balance bill. You would go to this process. If there are in-network providers who are able to furnish care, your next question is, has the appropriate notice of consent been received by the patient? If it's a yes, again, you're allowed to balance bill them. That's the point of that notice and consent process. If no notice and consent was received, you cannot balance bill them, and that's where you would result or revert back to this IDR process. Now, last one again, I think we could probably do an entire webinar on just this process alone, but I wanted to really keep it at a high level here so you are aware of it and really make sure you're aware of the timelines and when it would apply. This specific process is really the subject of many lawsuits that are currently going on with this legislation and may change, which is why we didn't want to do an entire deep dive on that, as we might see some changes coming on the pipeline here. Okay, well, we have made it through kind of the what I'll call the meat of the presentation, covering the practice impacts. Now we're going to look at what enforcement's going to look like with these current regulations, and as well as current updates that's going and ongoing with this. There's been a lot of activity around this legislation since its inception. So I'm actually going to go ahead and turn over to Holland to take you through these next few slides. So Holland, it is all yours.
Awesome, thank you, Lindsay, for that. So when we look at enforcement, or how HHS is going to enforce this, we have to look at how they are notified of noncompliance. One of those sources we know is your patients. So patients can now go online and submit a complaint via a web portal about your practice or your providers in regards to surprise billing. You can see a screenshot of that web page above. It's kind of what it looks like. So again, patients can now submit that complaint via phone or web portal about your practice or your providers regarding surprise billing. So now enforcement itself is a little different than what we're typically used to, right? So typically we just get to say the OCR is going to come knocking at your door with random audits or if someone complains about you. However, with this act, states will actually have primary enforcement authority. So this is the case for both of issuers who offer health insurance coverage in the individual or group markets in the state and for facilities or providers offering services in the state. However, if that state does not provide adequate enforcement, that's when CMS is going to step in and take over enforcement. Now, don't get your hopes up too much. CMS is a creature of habit. So of course, they had to throw it in there that they may also conduct random or targeted investigations of providers or facilities. So now, whoever the enforcing authority is for your practice, they must provide notice of a violation. And that's going to include the information that prompted the investigation, as well as the potential for a civil monetary penalty or the imposition of corrective action plan. The violator is typically going to have 14 days to respond, although that period could be shortened to 24 hours or extended to up to 30 days or more, depending on the circumstance according to CMS. So they are really giving themselves a lot of leeway here. Again, they are a creature of habit, and that's pretty typical in what we see of certain CMS enforcements. So the civil monetary penalties for violations are up to $10,000 per violation. So in determining what penalty to impose, CMS is going to consider a variety of factors, including the degree of culpability, history and frequency of prior violations, the impact on affected individuals, the gravity of the violation, and whether any violations have been corrected. The penalty will be waived if a provider or facility does not knowingly violate, and here's the key, should not have reasonably known it violated the act, and reimburses any incorrect payments plus interest. So I am sorry to say, but it is safe to say all of you should know about this act by now. So now to expand a little bit more on the state enforcement. Just recently, CMS published a comprehensive list of state enforcement letters for the requirements under the No Surprises Act. These state letters outline CMS's current understanding of which surprise billing requirements each state is enforcing and what requirements CMS will enforce. The letters also outline whether the federal independent dispute resolution and patient-provider dispute resolution processes apply in each state and under what circumstances. So these state-specific letters will help providers determine what governing body is going to oversee their surprise billing requirements. We have provided a link for you to look up your individual state letter or letters, if you have multiple locations in multiple states. Sadly, I have not read all 50 letters, so any specific state questions, I will refer you back to this link as well. So now if you are subject to enforcement for an NSA violation, HHS may impose a $10,000 civil penalty against facilities and providers for violations, as well as they do have the ability to waive the penalty if the facility or provider, again, did not know and should not have reasonably known its actions violated the rule, or the facility or provider reimburses the health plan, insurer, or patient as applicable within 30 days of the violation. So now, due to the complexity of this legislation, it should come as no surprise that it is constantly evolving and being challenged. So here are some of the recent court updates that we think are important that we've taken note of. First and foremost, there are currently 8 lawsuits that have been filed challenging the No Surprises Act since December. 8. The cases have been filed by some really big players you can see above. We have the American Medical Association involved, American Hospital Association, American Society of Anesthesiologists, American College of Emergency Physicians. There's some really big notable players up in those lawsuits. So all 8 of these lawsuits challenge that IDR, or the independent dispute resolution process. They take issue with the rule's requirement that independent dispute resolution entities presume the qualifying payment amount. The insurer or plan's median in-network rate is the appropriate out-of-network payment amount. A court decision has only been reached in 1 of the 8 cases. In the Texas Medical Association case, the judge ruled in its favor, saying the rule, quote unquote, places its thumb on the scale for the qualifying payment amount. HHS appealed the decision in April of 2022, but it later asked the court to hold its appeal until it releases the final surprise billing rule this summer, which again is why we didn't go too deep into the IDR process, just in case it's completely overhauled in the coming months or this year. So in other news, Blue Cross Blue Shield Association and American Health Insurance Plan released a report that determined that the No Surprises Act prevented more than $2 million of unexpected medical bills to commercially insured patients in the first 2 months of 2022. So more than 12 million potential surprise bills will be avoided this year if this trend continues, according to that study. So we can see the implications on both sides, as a healthcare provider, but maybe also as a patient. So what can we expect next steps to be with the No Surprises Act? Here are some of our best guesses. I think we're going to see some of those court cases kind of come, to a conclusion that are going to determine immediate future of the legislation. I do also believe, the federal government is going to continue to publish new guidance, as well as the state is they will continue to adjust their own laws. And if it's anything like what we expect to happen, it's likely that those states and the federal laws are going to begin to harmonize. I also feel that there is going to be an increase in those IDR cases that we've seen so far. And we could expect a final rule on the federal IDR process. We also, are going to see some penalties coming through in the next coming months as this, again, kind of starts to play out throughout the end of the year. So what should your next steps be in this? Feel free to visit our website and continue to sign up for our webinars, but also consider working with our government incentives teams to offer guidance on topics exactly like this one. We do also host these informative webinars as much as possible, and there are opportunities to also test drive our products. So with that being said, we have Lindsay's contact information here on the screen, but I am going to turn it back over to Chelsea to take away any questions that we got today. So Chelsea, if you are ready to take it away.
Yes, thank you so much, ladies. And again, thank you everybody for joining us today. It looks like we have about 5 minutes here to crank through a bunch of questions. So I'm just going to start going through these in the order that we received them. And I'm going to skip over a couple that I think was pretty evident that we did already answer in the presentations that I saw that you might have already sent through before we got to that part. Okay, so first question. Does no surprises protection apply to all patients in all types of insurance?
I can jump in and grab that one. So generally, the No Surprises Act is going to apply to patients that are enrolled in healthcare plans or some sort of health insurance. Again, that's going to include anything from federal marketplaces, employer-based, state-based marketplaces. The one call out I do want to say is that it's not going to include patients that have Medicare, Medicaid, I believe it was Indian Health Services and even Veterans Affairs or TRICARE. So those types of insurances wouldn't apply. Mainly the No Surprises Act applies to those that are insured. The only portion that applies to those that are uninsured is going to be that good faith estimate portion.
Okay, perfect. Thank you, Lindsay. Next question. What clinicians must provide the GFE for services to uninsured or self-pay patients?
So this is a good one, and I've gotten this a lot. So this applies to all providers. So this is going to all providers regardless of setting. I know I kept, trying to hone in on the fact that the surprise billing portion applies really to only those for hospital or ASC or some sort of emergency department. The good faith estimate requirement is going to apply to all providers, any setting. You have to provide uninsured or self-pay patients with that estimate for services upon scheduling care at least 3 days in advance. And that's a separate requirement, again, from that balanced billing patient protections. This applies to any clinicians that's providing patient care under their license, including physician office visits.
Great, thank you, Lindsay. Next question. Is a provider or facility required to provide a good faith estimate to uninsured or self-pay individuals upon scheduling same-day or walk-in services?
This is a great question. So yes, I've had a lot of kind of feedback from providers about what about walk-in or same-day appointments. How do we handle that? So the short answer to this is no. The requirement to provide that estimate to any sort of uninsured or like we said, the self-pay individual, it's not triggered upon scheduling an item or service if that service is going to be scheduled fewer than 3 business days before that service is provided. So what's that saying is if it's not scheduled out within, at least before 3 days, then that's not going to be triggered. We're okay with that.
Okay, thank you for that clarification. Must a good faith estimate include a diagnosis code even if the provider does not know the patient's diagnosis at the time of scheduling?
So this is going to be, you're going to be required to provide a diagnosis code only where one is required for the calculation of the good faith estimate. So it kind of seems like a backward answer, but if it's needed to provide that estimate, then yes, you can put it on there. We already went over what would happen if the estimate needs to change for any reason because something happens with care. Just know that that estimate needs to include the expected charges and service codes for the items and services that are expected to be furnished during that visit, even when no diagnosis code's available.
Okay, thanks. And it looks like we have 1 more minute, so we're unfortunately going to have to make this our last question. But again, please reach out to your compliance or legal department because these questions are really great ones and they definitely do need an answer. So don't hesitate to ask people for help on this because it's really important. So Lindsay, for reoccurring items and services, does a GFE need to be provided for each instance of reoccurring items or service?
Great question. So where, your provider, if you're expecting to furnish any sort of reoccurring service, right? Think of like periodic counseling services, maybe you provide PT services, you can actually just issue a single good faith estimate for those reoccurring, items or visits rather than an estimate for each instance. That scope of that good faith estimate can exceed 12 months though. So this is something I've obviously had to look up for some of our own clients. But if there are additional reoccurrences of these, recurring services, think PT or something beyond that 12 months, then you have to provide a new estimate. So you're good to provide one if it includes them all, it just can't go past 1 year.
Okay, perfect. Thank you, Lindsay. And again, thank you everyone for joining us today. As a reminder, next week we are doing a webinar on MIPS, what to expect for 2022 and beyond. So keep your eyes out for the invite that you should see today. If you don't receive it, you can visit us on social media and we'll have it posted on there as well, or shoot me an email. I'm the one who sent out the invitation and the webinar invites for this. So any way you can get a hold of us, let us know. We're happy to help and we look forward to seeing you next week. Have a great day.
Thank you, everyone.
Thanks, everyone.